Professor.
Chairman Durbin, Ranking Member Grassley, and members of the committee, thank you for the opportunity to testify today. It's an honor to appear before this committee to discuss this nomination. As the hearings have so far demonstrated, Judge Jackson has a wealth of experience and is very well respected. I'm grateful for the opportunity to participate in this body's serious and substantial consideration of a nomination to serve on the nation's highest court. My testimony will focus on the constitutional doctrines applicable to the role of the court within our constitutional system and on judicial philosophy. As its preamble states, the Constitution was ordained by the people to establish justice and form a more perfect union, and the nomination process under consideration today in many ways demonstrates the success of that effort. The Constitution's text and structure include two critical framework protections for liberty: federalism, the division of power between states and the federal government with significant freedom retained by the people and their critical institutions like the family and religious bodies, and the horizontal separation of federal power across three distinct branches. The Federalist structure is perhaps the primary protection of the two in that it lays the foundational threshold groundwork for the enumerated limited nature of the powers that any branch of the federal government may exercise. The Constitution does not empower the federal government to enact just any law in any form. Rather, Article 1 sets forth limited, enumerated powers vesting only those legislative powers herein granted in that article to the policymaking body of the U.S. Congress. The constitutional structure also intentionally makes federal action difficult and cumbersome, serving as a brake on the federal government's ability to regulate people even within its enumerated areas of authority. One's interpretation of the proper role of these structural safeguards is a critical component of one's understanding of the role of each of the three federal branches and is critical to shaping judicial philosophy. The component of federal power, of course, front and center today is the vesting of judicial power. That authority under Article 3 extends only to the power to resolve cases arising under the Constitution, federal laws and treaties under them, and certain categories of controversies. As the discussion during this hearing demonstrates, that power constrains a judge to application of the text and rule of law, not shifting policy preferences, cultural norms, or extensions emanating from governing text. The Article 3 limited authorization to resolve concrete cases and disputes ensures that the Article 3 judge is not charged with general responsibility to decide questions of national policy or the power to offer advisory opinions on legal questions. And particularly when deciding cases arising under federal laws and the Constitution, the Article 3 judge must faithfully interpret and apply the text. And the limited power to decide cases and controversies also suggests caution in the imposition of remedies. An Article 3 nominee's judicial philosophy should reflect deep awareness of these limitations. As a number of Supreme Court nominees before this body have previously testified, the interpretive philosophies most consistent with the constitutional role of a judge are originalism and textualism. Those methodologies, generally understood, essentially seek to identify the ordinary meaning of the relevant legal text at the time that it became governing law. Originalism is applied through the identification of original public meaning at the time of ratification is consistent with constitutional provisions such as Article 7, providing that the Constitution will become governing law as of its ratification by the conventions of 9 states. Judges must take a constitutionally required oath to be bound by this Constitution and the laws of the United States made in pursuance thereof, and it's the text of those laws that have supreme effect. Finally, the Constitution provides for a finely grained amendment process with substantially challenging procedural hurdles. This process cannot be overcome by jurists developing sense of cultural norms apart from constitutional text. Original public meaning's commitment to identifying the meaning of constitutional or amendment text at the time it's given effect is consistent with these principles, and the statutory interpretive methodology of textualism similarly maintains consistency with these constraints. Just as Article 7 procedures give authority to the constitutional text, Article 1, Section 7 procedures indicate that statutes have governing effect once they're enacted by Congress and the President. Therefore, the text of those enacted laws, the publicly understood text is at the time of its enactment, governs the proper interpretation of these laws. In testimony and statements, Judge Jackson, like prior nominees representing a range of views and jurisprudential approaches, has articulated general support for originalism and textualism, but commitment to these methodologies hinges on their application in practice. When asked about judicial philosophy, Judge Jackson has declined to identify express commitment to a particular philosophy, instead focusing on a multi-step interpretive method, highlighting the steps she'd taken in deciding cases, such as looking at briefs, the factual record, congressional intent, purpose, and precedent. It's challenging to definitively discern or predict a jurist's future methodological approach in the Supreme Court on the basis of service on a federal district court, but hesitance to commit to a particular judicial philosophy could leave flexibility for incorporation of various interpretive approaches during Supreme Court service, and Judge Jackson's explanation of her interpretive methodology during the hearing suggests perhaps more reliance on legislative history and extra-textual sources and purpose than that used by textually committed jurists like the late Justice Scalia, Justice Thomas, and more recent nominees like Justices Barrett, Kavanaugh, and Gorsuch. In addition, some of Justice Jackson or Judge Jackson's prior body of work suggests that she also may have a different view than a traditionally applied methods of originalism. In the recent decision involving a conflict between the Congress and the executive branch, Judge Jackson inferred an implied cause of action from the Constitution, a determination that was later reversed by the D.C. Circuit, finding that inference of an applied cause of action outside the judicial role. This body is appropriately weighing constitutional principles, the role of the Senate and the federal judiciary, and interpretive philosophy in its consideration of nominees. The interpretation of law consistent with originalism and textualism as traditionally applied is important to maintain limits on governmental power and to preserve liberty. Thank you very much for the opportunity.